Welcome to the Kevin Mannix Report. I'm Kevin Mannix, your host for this program, and we appreciate your joining us to gain a little more insight in public officials, into what they do in government, and what happens in our communities. Our guest today is a gentleman who has had a long record of public service and who now is at the top of our judicial system in the state of Oregon. He is the Chief Justice of the Oregon Supreme Court, Wallace Carson. Welcome to the show.
Thank you, Kevin.
We always try to gain a little bit more insight into the background of individuals, at least through the interview process. And folks in the audience always kind of hear from government officials about policies and issues or whatever, or the system. But they don't get enough information, I think, about the person behind that. So if you don't mind, I'd like you to give us a little bit of an idea of where you're from and tell us a little about your family.
Well, thank you for the opportunity. I'm very pleased to do that, Kevin. I think I'm about a fourth-generation Oregonian, primarily in the eastern part of the state, in the La Grande area in Union County. My grandfather came to Salem in 1889, and he was a lawyer and had 5 children, 3 boys and 2 girls, and they were all lawyers. And I was born here, as was my wife, and went to Bush Grade School and Leslie Junior High School, which is now Leslie Middle School, and Salem High School. I'm so old that there was only one high school in Salem at the time. And so went to Salem High and then off to college. And so the family's been around this area, and my aunts and uncles and cousins and everybody else. So,
what drew you into the law?
I suspect the fact I grew up in a family that was law-oriented, and so I kind of had in the back of my head that I might want to be a lawyer sometime, and I wasn't sure. My father, I think, to keep the pressure off of me, made me promise that I wouldn't be a lawyer, that I'd seek some other career. And I did think about insurance and some of the other matters when I was going to college. But after I got off active duty in the Air Force and came back, it was readily apparent to me that I really wanted to see if I could pass law school and pass the bar and be a lawyer. So I did, and then joined my father and one uncle who was still living in the family firm in downtown Salem.
Well, before we get into that practice, I'm curious about your service in the Air Force. If I remember, not only were you on active duty, but you were in the reserves for many years. Can you tell us a little about that?
Well, sure. Right after I graduated, got my commission through the Reserve Officer Training Corps at Stanford, and then married the following weekend, and my wife and I went down to Texas to start my Air Force career in the active side. Went through pilot training and was trained in single-engine jet fighter training. And then from there, they sent me to Korea. This was long after the Korean War. I'd asked for the West Coast, and the Air Force misunderstood. I meant the West Coast of the United States, and they thought I meant the West Coast of Korea. So I went to Kimpo, Korea, K-14. Came back and then was in the Reserve, Air Force Reserve, for 11 years, and then finished my career with 20 years in the Oregon Air National Guard. So I had a total of just short of 35 years in the Air Force in a variety of different capacities.
Did you continue flying in the Air National Guard?
No, I flew, but I was not, I did not have a pilot's billet. I'd try to beg a back seat whenever I could, so I got to fly in some really nice aircraft, and but I never got checked out in them. I was a ground pounder after I got out of active duty.
Well then, as far as the law practice went, you went in with your family, and how long were you doing that before you got into politics in the community?
Well, actually, I'd started politics. I think I went door to door for Doug McKay when I was 7 or 8 years old in our neighborhood on Leslie Street, and ran, as many of us have, for school offices, won some, lost some, and same in college. And so I passed the bar and started practicing in 1962 and decided to run for the House of Representatives in 1965. So it wasn't very long after I was pretty sure.
So you had it in your blood, eh?
I did, and my grandfather had been a state senator, and my uncle had been a state senator, and I like politics, still do. So I thought that, I didn't know whether it be school board or city council or whatever, but I thought the legislature, I followed the legislature when I was in school, and so I decided I'd run for the legislature and was fortunate enough to get elected in 1966.
Now, can you tell us a little bit about how you balanced your practice versus legislative service, which is always tough for our part-time citizen legislators?
Well, you know probably better than most how difficult it is with your lawyer/legislative experience. I had the advantage of having a father and uncle in the practice. The Capitol building was, 7 blocks away from the office, so I'd go to the office in the morning, go up and do the legislative work, and then go back to the office in the evening and balance it. Very difficult to balance. We who are in the Salem community close to the Capitol have an advantage. A lawyer's a good friend of mine, and I'm sure you remember Tom Young was a lawyer in Baker City. How he balanced all of that, I don't know. It's very difficult. But when you're close to town, you can stuff in those little pieces of time and carry on a semblance of a practice. But of course, it was easier then than it is now. My sense of it is that there are more things going on constantly for legislators now than there were. We actually had an interim where we could go back to work.
In fact, yes, traditionally the legislature is supposed to be in session about 6 months, and then we have an interim for a year and a half, but it seems like the interim gets filled more and more with more committee work, and the workload continues to grow. And I suppose as society grows and things get more complicated. But tell me, what was the most enjoyable aspect of your service as a legislator?
I think it was the people. I love the law, or I wouldn't be in it. And practicing law and making law are very exciting to me. Some people find it rather boring to puzzle over words and purposes and make things work from a law standpoint. I found them fascinating. And so whether it's practicing law or judging law or making law, and those are 3 separate distinct roles, I've found it very interesting. And in the legislature, when I was there from 1967 through 1977, it was a quieter, and I think it was more fun, I would assert. I'm not there now, obviously, but I sense it was just a lot more fun to serve. It was more relaxed than it is now. And so I'd say the people. I really do miss the people with whom I served in the legislature. They were a delightful group. Didn't always agree with them, but that's okay.
Well, when you mention that, the comparison, of course, you do have an opportunity to go by and observe or participate in the process as chief judge, and we'll get to that a little bit later. But let's talk in the meantime about how you transitioned to the circuit court. 1977, you were appointed circuit court.
You have a good memory, yes.
Can you tell us a little bit about that experience?
In the session in 1977, we increased the number on the Court of Appeals. It had been a 6-person court, and they increased it. The legislature, I opposed it. The courts wanted to move, the bar, Oregon State Bar wanted to move slowly, transitioning from the intermediate court, or from a Supreme Court that heard all the cases, to an intermediate court, the Court of Appeals, that would be a mid-level and hear most of the cases first off, and then a discretionary review of the Supreme Court. But then Chief Judge Herb Schwab was a very forceful political figure, a very good judge, very good lawyer, and he convinced the legislature to increase the Court of Appeals to 10. And so that bill passed, signed by the governor, and although I opposed the bill, I threw my hat in the ring for one of the appointments. I didn't get it, but Governor Straub was kind enough to call and see if I'd be interested in a position that opened up through the untimely and very unfortunate death of Judge Jenna Schlegel, who was a wonderful person and judge, had passed away, and Governor Straub offered me the opportunity to be a circuit court judge, and I said yes. My father had been a circuit court judge for a period of time. He didn't like it. I loved it. It was fun, and it was a good experience and good people.
So how long were you on the circuit court bench before you were moved to the Supreme Court? I
was there about 4.5 years, and then Governor Atiyeh, when Arno Deneke, who was the Chief Justice then, retired on June 30, 1982, I and several other people threw their hat in the ring to be named to the Supreme Court, and Governor Atiyeh kindly appointed me actually appointed me on the 12th of July of 1982, and I pro tem'd in to hear arguments on the 13th, and I was sworn in on the 14th of July, Bastille Day. So
that's a good way to remember that.
Yes.
The transition would be significant, I think. You might want to describe the difference between the trial court, the circuit court bench, and we can talk about the Supreme Court, but I think the audience would be interested in that difference.
That's a very good point, Kevin. There's a substantial difference between the 3 levels of court, the trial level, the intermediate appellate level, and the senior appellate or the Supreme Court. Some lawyers don't quite understand the difference, and so when I go out and speak at law groups, I try to we're not a third-level jury, so don't make jury arguments Supreme Court. We're a law-deciding court, and what that means is that we don't worry so much about the facts. We don't decide whether the light was red or green. That's already been done at the trial level, been reviewed at the intermediate level. And most of our cases, we take what we call discretionary review by petition. The U.S. Supreme Court refers to it as a writ of certiorari, and it merely means that people ask the court to take the case. The court doesn't have to. And since the start of the Court of Appeals in 1969, our Supreme Court here in Oregon has been primarily, it's changing slowly because of legislative activity, but we're primarily a discretionary court. And the main difference is the trial judge is kind of a committee chair is the way I look at it. People ask me at the time, this is quite unorthodox, I don't think you'd get this response from most judges, trial judges, what was the best experience for me transitioning into the trial court? And oddly enough, it was committee chair in the legislature. I saw more similarities between what a committee chair does in the legislature, or a committee chair anywhere, than, say, a trial lawyer. I used to say I was a trial lawyer, and I was in a sense, but a busy trial schedule for me would be one case a month, and that's, in modern terms, is not a very heavy schedule. But the necessity to know the rules, to know where you're supposed to go, to keep everything in order, have the proper decorum, have everybody heard appropriately, and assist people in making the decision is what a chair does, and that's also what I believe a trial judge does. You're not an advocate, and you are to be impartial and not take sides, and so transitioning from a trial lawyer with your experience is surely helpful, but I think that's quite a leap from being an advocate to being an impartial adjudicator. And then when you move up to the appellate level, you don't have witnesses, you have lawyers make arguments to you when you have oral arguments, but most of it is reading and then writing. It's a quieter life, but it's an intellectual challenge. Not that trial court isn't, but it's more intellectual than it is dealing with people. Now that's the downside too, if you like to deal with people, when you kind of like going to a monastery when you go up to the Supreme Court. And then people suggest that we try hard to keep connected with the community, and so we don't become monkish in our review of the law.
Well, the difference too, it seems to me, the Court of Appeals still sees a few cases, a few kinds of cases with de novo review, which means they'll review the record again, as I recall.
That's correct.
And that means that they could make a different factual determination. But as I understand it now, there's virtually nothing that goes to the Supreme Court where you would read a transcript and try to redetermine facts. Basically, that's all off the boards now, and the Supreme Court focuses on the legal principles involved in the case.
That's absolutely correct. We still have the authority or power to do de novo review the facts and the law, and even the amended Article 7 of the Constitution, which was changed in the first part of the century, gave the Supreme Court rather vast power to decide a case at what is now the third level. The Supreme Court over the last 90 years has chosen to do that seldom. And
in other words, the court has the jurisdiction and power, if it wishes, to review in that format, but it chooses not to.
that's correct.
All right.
Absolutely.
Now, in that role, folks think, of course, of witnesses being interrogated and all of that. Perhaps it's good to explain that basically the record is transcribed and the exhibits are presented, but since most of the cases have been filtered through the Court of Appeals, the cases that are what I dare call no-brainers have been taken care of. And, of course, the Court of Appeals has to deal with some difficult cases,
They
too.
do.
But they also affirm without opinion in a large number of cases where they just say, well, you've had your shot, we heard your argument, we don't even think that we need to write an opinion here, we're satisfied that the trial level handled this properly.
Correct.
And it often happens with administrative cases as well as criminal law cases. The Supreme Court, on the other hand, when it's accepted a case, has basically said, well, we do want to offer an opinion, we may not be sure what it is, but we want to get into the issues in this case. Do you look for matters that are new legal issues? Are there some things that the court is looking for in deciding whether or not to grant review?
Yes, Kevin, there are, I've forgotten the number, 11, 10, 12 items that we review. They appear they first started in the cases themselves. The court explained it. We now have them in the Oregon Rules of Appellate Procedure. with which you're familiar, and it just lists the things that the court is looking for. Law issues, broad impact for the Oregon community, areas that are, what would I say, politically, but I mean of great interest to the public that needs a response or needs the Supreme Court to resolve it, conflicts between statutes and between case law. Those are kind of the areas that we look for, and so they're usually fairly difficult cases, or there wouldn't be much of an argument. If the legislation was clear or the case law was clear, there wouldn't be much of a fight. But it's where there are differences of opinion that we usually take the cases. And you're right, the Court of Appeals is one of the hardest working appellate courts in the country, and they do a fine job.
I'm going to pause for a moment and mention to our audience that you're with us on the Kevin Mannix Report. And yes, you guessed it, I'm Kevin Mannix, your host. Our guest today is Chief Justice Wallace Carson from the Oregon Supreme Court. If at any time you have any questions or concerns, we always welcome a call or a written message. You can reach me at the Kevin Mannix Report, 2003 State Street, Salem, Oregon, 97301. We also have a phone number that you can call and leave a voicemail message. And that number is 391-8031, 391-8031. That's the Salem area code, which is 503. We're always glad to hear from you, and we will get back to you with a response. Turning back to our guest today, Wallace Carson. Where did Wally come from? Is this the family nickname, or?
Well, actually, it's I think it's not the diminutive of Wallace, but I'm Wallace P. Carson Jr., Wallace Preston Carson Jr. And my father was Wally, and so I became the junior, and it was always very confusing to have two Wallies. When I was young, it was Big Wally and Little Wally, and then I got larger than my father, and that became a problem. I didn't mind Young Wally. He objected to Old Wally. So it's just been a family name, my father's name. Very proud of it.
There's something that people may not have noticed, but I've observed as I've gotten older. I'm 48 now. People that I knew personally before, say, they went on the bench, I'm still comfortable referring to them by their first name, such as Mick Gillette is still Mick to me because he was Solicitor General when I was an Assistant Attorney General. He was my boss, and so it was Mick. Now, I wouldn't say that to him in a formal proceeding, of course. It's Judge Gillette. But have you noticed how people go through these evolutions? To me, you're always Judge Carson because that's when I really got to know you. You're a circuit court judge, and I would, if I'd known you earlier as Wally, maybe I'd be talking to you that way. Do you run into that, though? People kind of wonder how to address you in different circumstances?
Indeed, and my answer, and it's only my answer, Wally's just fine in any circumstance but when we're on the court, and then I think the decorum, I have a title and I should be called by that title, but other than that, Wally is my family name, and I'm very comfortable with that. When I ran for public office, one of the more difficult things was what name to use. Wallace B. Carson Jr., and people argued, well, it shouldn't be the junior, but I didn't want the people to be confused about whether they're electing my father or me. So it became Wallace B. Carson Jr., and that handle has been the one I run. That's how I appear on the ballot, even more recently. It is difficult, and there's also that subset between judge and justice. Those of us on the Supreme Court prefer to be called Chief Justice or Justice. There are those who say the only justice mentioned in the Constitution, our Oregon Constitution, is the Chief Justice, so they will call me Chief Justice, but everybody else is a judge. So you can't go wrong by calling a person judge, whether they're a Supreme Court, Court of Appeals, trial court, tax court, whatever it may be. But it does cause confusion. People aren't sure what to call you. I've also found that it's also helpful. They may not remember your name, but if they remember your title, hi, Judge, and they're not embarrassed by saying, who was that person?
So when someone sees you on the street, should they say, hello, Judge?
They may, or they can say, hello, Wally.
Okay. As we go through this process, I should mention it. One of the things about the appellate process is that you have oral argument in your cases. The cases are brief, which the briefs never seem to be brief.
They're not brief.
You do have rules, at least, that restrict their length so they won't be too long.
True.
But the written arguments are presented to the judges, justices of the Supreme Court, and so they've been read ahead of time. But then you're into oral argument, and I don't know if the public understands what that's all about. Maybe you could explain that.
I'll try. Just as you said, there's a petition filed. If we accept or allow the petition, it takes 3 of us of the 7 to allow the petition. Then it's briefed on the merits, it's called, and that is a written report, if you will, or a written argument of why the law ought to be changed or the law ought to stay the same. Then we have the oral argument, and it's an opportunity, primarily in my view, for the court to ask questions of the lawyers. After reading all the material, being somewhat familiar with the record in the trial court or in the Court of Appeals, it's the opportunity for the court to say, I don't fully understand this, or have you considered this? Most people think of it as an opportunity for the lawyers, and sometimes it works that way, for the lawyers just to talk for half an hour. That's a bad argument. If that's all that goes on, then it means the court and the lawyers aren't engaging in a conversation. That's how I view oral arguments. I would prefer it to be called an oral conversation. Of course, maybe that's redundant, but sometimes it's just a presentation like in speech class in high school, where the proponent for change or reversal can save 10 minutes for rebuttal, and they're given normally a half hour each side, and so it'd be 20 minutes for the appellant, if you will, or petitioner. And then the respondent has 30 minutes, doesn't have to use all the time, they usually do, and then 10 minutes of rebuttal.
My observation would be that the best oral advocates draw the court into that conversation.
Absolutely.
Rather than stand up there and just recite a litany of principles.
That's quite true.
I would get nervous if my oral argument didn't elicit some questions.
Yes, the most experienced lawyers start worrying if they've 10 minutes into their presentation and we're just sitting there looking at them, and that means we're not connecting. And we have very good oral advocates at our level and perhaps at all levels, but we are treated to some really fine advocacy, and so it doesn't happen very often that we go without questions. And there's some of us who ask a lot of questions, and there's some of us that ask very few. I don't ask many questions, but there are others who 10, 15, 20, 30 questions of an argument.
I would just, from my limited observation, gather that perhaps Justice Gillette and Justice Durham like to ask questions.
I would say that your friend and mine, Justice Gillette, is very bright and gets into a case, and yes, indeed, he asks a lot of questions, and good questions.
Now, with your 7-member court, it's a collegial court, and perhaps you could help folks understand how that works in terms of decision-making.
In the Oregon court, and I didn't know this until I got on the Supreme Court and started meeting justices from other states. It's not true across the country, but Oregon has had a tradition of a collegial court, and the 7 of us come together and decide issues. The way it works in the Oregon court is after oral arguments we have what's called a post-argument conference, and a straw vote is taken to see whether it's affirm or reverse, and it's not binding, and it's kind of a hip shot because we haven't thought a lot about it, but it enables me as Chief Justice then to make an assignment of the case. And for instance, if I were the only one who wanted to reverse, there'd be no point in me assigning the case to me. The straw vote, however, is not binding, as I mentioned, and it's not rare where we'd all 7 of us would say affirm, but ultimately when the opinion is written, it's reverse. Once I get the straw vote, then I assign the case to a judge who's on the apparently on the majority side. An opinion is written, and then it's circulated. We do both written critiques, all of us, of the opinion, and then it comes back to conference. And we have conference usually about once a week, and we discuss what cases to take, but we also discuss the opinions. It's very rare that the first draft goes out onto the street. It usually goes back to the author to do some work, and sometimes we've had 20 drafts on some rather knotty cases, but usually somewhere in the 3 to 5 range we finally get agreement. We try very hard to have a majority and not a plurality, and let me explain that. We try to have at least 4 of us agree on the rationale and the decision. Oregon has had a tradition over the last 45 years of maybe only 30, 35 plurality decisions, which are very common on the U.S. Supreme Court, as you're aware. That doesn't send a very good message. You're all
Leaves things in doubt for later.
It does indeed. And so we try rigorously to have at least 4 of us agree on the rationale and on the outcome. And we don't always reach our goal, but we do fairly often. And then there'll be some who want a dissent, and that simply means I disagree with those people. And some will concur, which is normally it's just saying the majority has it right, but I'd like to say something else. And somewhere in the neighborhood of 75% of our cases are straight out unanimous, and the other 25 have dissents or concurring opinions.
In terms of leaving things in doubt, that's always an invitation for further argument later about what the court meant or whether or not the court means to adhere to that doctrine. So I could see as a matter of policy how you would prefer to say we've made a definitive statement, let's move on to the next subject.
Right.
In terms of the decision-making process, I'll caution you that I'm not suggesting this. In fact, I would think it would be a terrible thing to do because the system works very well right now. But have you had any trouble with the press or others saying, well, this should be an open process, we should be able to have people in the room watching you talk about these cases and that sort of thing?
I'm sure those conversations have gone on. I know they've gone on in other aspects. The Supreme Court, in fact, in a case called Oregonian versus Diaz, probably in the late 70s, said all courts are open. And at that time, we'd had juvenile hearings were closed, mental hearings were closed, and as a result of that, our Supreme Court decision, I wasn't on the court at the time, we opened all the courts. They did say that deliberations by the grand jury are closed, and by the petty jury, the regular juries, and also deliberations of the Supreme Court are closed. We have public meetings when we do our administrative side. We have public meetings, and we give the press we give them notice just like any other public body does. And they are open for people to come by. They're not a very high level of interest out there, but those are open, and of course all our arguments and all our court hearings are open. Whether we're in the court building or in high schools, we go out 2 or 3 times a year to high schools around the state and hold our oral arguments in those vicinities, trying to educate and allow the community to participate in our program. We try to respond to questions that the students or the townspeople have. But other than that, our deliberations are private.
Well, and there's good objective reasons to present in favor of that. One of it, which is hundreds of years of tradition.
Right.
But the other is that you're talking about a process that's different from policy making by the legislature or rulemaking by the executive branch. You're talking about interpretation, and it's also a decision about a case involving usually private parties versus sometimes the government or a variety of individual interests. It's really the deliberation process, but the information gathering process is what's open.
That's true.
Well, do you see any particular direction that you'd like to talk about in the next 30 seconds to 1 minute? Or should we just say that things are pretty much on an even keel? You've got the court moving, you're moving your caseload, you're keeping current. Is there any last shot you'd like to give us on the show today?
Thank you. We're not as current as I'd like to see us, but we're doing reasonably well, but we need to get some more productivity. The final message would be is that we've adopted a vision for the courts for 2020 after a couple of years of study, and we're continuing to study that. We're going to try and make the courts more user-friendly, and we've made a major effort to move with community courts where the courts will actually move in the communities, and they're going on in Multnomah, will be going on in Lane, Deschutes, Jefferson, Crook, and at least temporarily that's the list. So we're going to make a real effort to have all our staff and our judges and our programs more open to the public and more friendly to public use. It'll take some time.
So the shot will be community outreach, and of course the legislature should help you in that process if you need any modifications.
I would hope so.
With that, thank you for joining us.
Thank you.
And I thank our audience for joining us on the Kevin Mannix Report. See you next time.